Would you please call the case?
Good afternoon, Your Honor. This is case number IT 9511I, the prosecutor versus Milan Martic.
Thank you. May I have the appearances, please, for the prosecution?
Good afternoon, Your Honor. For the prosecution, Ms. Diane Bowles as case manager, and my name is Hildegard Oertzretzlaff.
Thank you. For the accused?
Poštovani sudija.
Your Honors, my learned friends, legal assistants, ladies and gentlemen, journalists, this is my first appearance before the International Criminal Tribunal here in The Hague. And therefore, I am bound to introduce myself to you, and I will do that with pleasure. I'm Strahina Kastratovic, lawyer from Belgrade. I'm afraid you will be in trouble pronouncing my name, but I suppose you will learn that. I will be the lead counsel in the defense of the accused Milan Martic. My legal assistant will be Marko Kastratovic. This is the young man sitting to my left. I will not give you the year of my birth, and deliberately so. I hope you will understand that and understand it. I have been a lawyer for almost 40 years, and no doubt thus you will be also able to establish what I've tried to gloss over. I also wish to say something which I believe is very important and which I think will affect our future work. Ms.
Kastratovic, I hope what you said is closely related to this initial appearance. I'll give you a chance if you have something to talk about the substantial matters for the initial appearance. Here, we just want to know your name and your co-counsel's name.
May I just say that I have problems hearing. It seems that my headset is not quite right and I can't hear very well.
Is that okay?
Okay.
You can hear me.
Da.
Yes, I can.
Zamolio bih ako možete da mi ponovite ono što ste.
But, Your Honor, could you repeat, please, what you just said, because I could not hear you.
Just now, I was telling you that I hope what you said is closely related to this initial appearance. I'll give you a chance if you have something to talk about. That is, the substantial matters for the initial appearance. Here, at this moment, we just want to know your name and your co-counsel's name.
Ja se zahvaljujem.
Thank you, Your Honor, for this instruction. I hope you will give me an opportunity to make some comments later on. I believe they will be of major importance for our cooperation with our learned friends and the Honorable Court, precisely because I think that there are certain matters which we shall be able to resolve easier if I point out them right at the outset. Thank you very much. I have given you my name and some information about myself.
I want to ask you, are you the counsel for the accused just for this initial appearance or for the whole trial proceedings?
Ja sam branitelj.
I am Mr. Milan Martić's counsel. I have been his counsel from the beginning, and I hope that if my health serves me well, I will be with him until the end with the team that I will appoint and which I have already appointed to a degree.
You may sit down, please. We will proceed with the initial appearance of the accused, Mr. Martic, pursuant to Rule 62 of the Rules of Procedure and Evidence. Mr. Martic, would you please stand up? Can you hear the proceedings in a language that you understand?
Could the microphone for the accused be switched on?
Da, razumijem se.
Yes, yes, I can understand everything.
Give your full name and the nicknames for the record.
Ja sam Milan Martić.
I am a Milan Martic. I have no nicknames.
What is the date and the place of your birth?
Rođen sam 18.
I was born on the 18th of November, 1954, in the village of Žagravići, municipality of Knin.
The address at which you resided before you were arrested.
Moja adresa je bila
My address was in Serbia, Vrnjačka Banja, Slatinski Venac, 11B.
Have you received the indictment against you in a language you understand? And did you have a chance to read it?
Da, dobio sam je.
Yes. I received it some 15 days ago, but I also saw it before that. That is, I have had the opportunity to read it and understand it.
Do you understand its contents?
Da.
Yes, I do, fully.
Have an opportunity to discuss the indictment with your counsel.
Onoliko vremena koliko.
As much as I communicated with him before I surrendered myself to the tribunal.
Being advised of your rights under the statute and the rules of procedure and evidence of this tribunal?
Da.
Yes,
Što sam.
some.
Thank you. You may sit down, please.
Hvala.
Thank you.
Anyway, I'll let Madame Registrar to read out Article 20 and 21 of the statute, which is about the rights of the accused.
Yes, Your Honor. Article 20, commencement and conduct of trial proceedings. The trial chamber shall ensure that a trial is fair and expeditious and that the proceedings are conducted in accordance with the rules of procedure and evidence, with full respect for the rights of the accused and due regard for the protection of victims and witnesses. 2. A person against whom an indictment has been confirmed shall, pursuant to an order or an arrest warrant of the International Tribunal, be taken into custody, immediately informed of the charges against him, and transferred to the International Tribunal. 3. The trial chamber shall read the indictment, satisfy itself that the rights of the accused are respected, confirm that the accused understands the indictment, and instruct the accused to enter a plea. The trial chamber shall then set a date for trial. 4. The hearing shall be public unless the trial chamber decides to close the proceedings in accordance with its rules of procedure and evidence. Article 21, Rights of the Accused. 1. All persons shall be equal before the International Tribunal. 2. In the determination of charges against him, the accused shall be entitled to a fair and public hearing, subject to Article 22 of the statute. Number 3. The accused shall be presumed innocent until proven guilty, according to the provisions of the present statute. 4. In the determination of any charges against the accused, pursuant to the present statute, the accused shall be entitled to the following minimum guarantees in full equality. A. To be informed promptly and in detail, in a language which he understands, of the nature and cause of the charge against him. B. To have adequate time and facilities for the preparation of his defense and to communicate with counsel of his own choosing. C. To be tried without undue delay. D. To be tried in his presence and to defend himself in person or through legal assistance of his own choosing. To be informed, if he does not have legal assistance, of this right, and to have legal assistance assigned to him in any case where the interests of justice so require, and without payment by him in any such case, if he does not have sufficient means to pay for it. E. To examine or have examined the witnesses against him and to obtain the attendance and examination of witnesses on his behalf under the same conditions as witnesses against him. F. To have the free assistance of an interpreter if he cannot understand or speak the language used in the International Tribunal. And G. Not to be compelled to testify against himself or to confess guilt.
Madam Registrar, would you please read out the indictment, please?
Yes, Your Honor. The prosecutor of the tribunal against Milan Martic. The prosecutor of the International Criminal Tribunal for the former Yugoslavia, pursuant to his authority under Article 18 of the Statute of the International Criminal Tribunal for the former Yugoslavia, Tribunal Statute, charges. 1. Since the summer of 1991, the armed forces of the Republic of Croatia, HV, have been engaged in an armed conflict with the armed forces of the self-proclaimed Republic of Serbian Krajina, ARSK. From the commencement of the war in the summer of 1991 until the end of the year, the ARSK, with the assistance of the Yugoslav People's Army, also known as the JNA, defeated the HV in numerous battles, taking control of approximately 1/3 of the Republic of Croatia including parts of East and West Slovenia and the Krajina. After the ceasefire in January of 1992, the United Nations Protection Force, UNPROFOR, was installed in the areas held by the ARSC. One area held by the ARSC in western Slovenia was the UN Western Zone, also known as Sector West, which remained under the control of the ARSC until the 1st of May, 1995. On the 1st of May, 1995, the HV attacked the ARSC forces in Sector West and drove the ARSC forces south across the Sava River into the Serbian-held part of Bosnia. In retaliation, the military forces of the ARSC were given orders by Milan Martic, the president of the self-proclaimed Republic of Serbian Krajina, RSK, to attack 3 Croatian cities, including Zagreb, the capital of the Republic of Croatia. The Orkan rocket, a long-range weapon, can be fitted with different warheads to accomplish distinct tasks, either to destroy military targets or to kill people. When the Orkan is fitted with a cluster bomb, such as used against Zagreb, it is an anti-personnel weapon designed only to kill people. On the 2nd of May, 1995, at approximately 10:25 hours, upon the orders of Milan Martic, Orkan rockets fitted with cluster bomb warheads were fired into the central part of Zagreb by the ARSC, causing death and injury to civilians in Zagreb. This was an unlawful attack against the civilian population and individual citizens. On the 3rd of May, 1995, at approximately 12:10 hours, upon the order of Milan Martic, the ARSC fired additional Orkan rockets with cluster bomb warheads into the central part of Zagreb, again causing death and injury to civilians in Zagreb. This was also an unlawful attack against the civilian population and individual citizens. The accused, Milan Martic, was born on the 18th of November, 1945, near Knin.
54, 90. Microphone, please. Don't make me older than I am. I was born in 1954.
Stand corrected by the accused. Milan Martic was born on the 18th of November, 1954, near Knin, Croatia. He is a graduate of the Croatian Police Academy and was a senior inspector with the Croatian Ministry of Internal Affairs. In January of 1991, Milan Martic was named head of internal affairs for the self-proclaimed RSK. He was reappointed to that post in 1993, and in February of 1994, he became president of the self-proclaimed RSK. He currently resides in Knin, the capital of the self-proclaimed RSK. General allegations. At all relevant times, a state of armed conflict existed in the Republic of Croatia. At all relevant times, the victims alleged in this indictment were civilians who were protected by the laws and customs of war. At all relevant times, Milan Martic was required to abide by the laws and customs governing the conduct of war. Charges. Count 1. On the 2nd of May, 1995, Milan Martic, as president of the self-proclaimed RSK, knowingly and willingly ordered an unlawful attack against the civilian population and individual civilians of Zagreb, causing at least 5 deaths and numerous injuries to civilian population and individual civilians of Zagreb. And in doing so, Milan Martic violated the laws and customs governing the conduct of war, a crime recognized by Article 3 and 7.1 of the Tribunal Statute, or alternatively, Count 2. On the 2nd of May, 1995, Milan Martic, as president of the self-proclaimed RSK, knew or had reason to know that a subordinate in the ARSK was about to commit and did commit a war crime, that is, the unlawful rocket attack against the civilian population and individual civilians in Zagreb. And Milan Martic failed to take the necessary and reasonable measures to prevent the attack and failed to punish the perpetrators of the attack. All in violation of Articles 3 and 7.3 of the Tribunal Statute. Count 3. On the 3rd of May, 1995, Milan Martic, as president of the self-proclaimed RSK, knowingly and willfully, ordered an unlawful attack against the civilian population and individual civilians of Zagreb, causing at least 2 deaths and numerous injuries to the civilian population and individual civilians of Zagreb. And in doing so, Milan Martic violated the laws and customs governing the conduct of war, a crime recognized by Articles 3 and 7.1 of the Tribunal Statute, or alternatively, Count 4. On the 3rd of May, 1995, Milan Martic, as president of the self-proclaimed RSK, knew or had reason to know that a subordinate in the ARSK was about to commit and did commit a war crime, that is, the unlawful rocket attack against the civilian population and individual civilians of Zagreb, and Milan Martic failed to take the necessary and reasonable measures to prevent the attack and failed to punish the perpetrators of the attack, all in violation of Articles 3 and 7.3 of the Tribunal Statute.
Thank you, Madam Registrar. In accordance with the Rule 62 of the Rules of Procedure and Evidence of this tribunal, the accused has the right to plead guilty or not guilty to each of the counts today or within 30 days from this initial appearance. Shall the accused fail to enter a plea within this time limit, the trial chamber shall enter a plea of not guilty on his behalf. Mr. Kastrotovich.
Yes.
Is your client ready to enter his plea today?
Da, ali
Yes, he is, but in using a general sentence, guilty or not guilty, not going into reasons for either. So the client will answer your question.
Yes. Mr. Martic. I'll now repeat the individual charges brought against you. And I'll ask you whether you plead guilty or not guilty to the specific charge. Your answer in each case should be guilty or not guilty, as the case may be. Do you understand that?
Da.
I do.
Very well. Let's begin. Count 1 contains a charge of an unlawful attack on the civilians on May 2nd, 1995, as a violation of the law or customs of law that you alleged ordered. How do you plead, guilty or not guilty?
Ne osjećam se krivim.
Not guilty.
Count 2 charges you, alternatively, with commander responsibility for unlawful attack on civilians on the May 2nd, 1995, as a violation of laws and customs of war. Do you plead the guilty or not guilty?
Ne osjećam se krivim.
Not guilty.
Count 3 contains a charge of unlawful attack on civilians on May the 3rd, 1995, as a violation of the laws and customs of war that you allegedly ordered. How do you plead, guilty or not guilty?
Ne osjećam se krivim.
Not guilty. And my counsel will provide further explanation. Why did I do what I did?
Count 4 charges you, alternatively, with commander responsibility of an unlawful attack on civilians on May the 3rd, 1995, as a violation of the laws and customs of war. How do you plead, guilty or not guilty?
Ne osjećam se krivim.
Not guilty.
Thank you, sir. You may sit down, please. May the Madame Registrar take note that Mr. Martić plead not guilty to the counts of the indictment. The registrar will be instructed to fix a date for trial when appropriate. The accused is to remain in custody until further order. Is there any other matter the prosecution wishes to raise at this stage? Yes, Madam Prosecutor.
Yes, Your Honor. It's actually 2 points that I want to raise. The first is actually an information for Your Honor. In relation to disclosure, today we have already provided the supporting material in English and also the transcript of the Rule 61 hearing in this case, including also the documentary evidence that was provided. This is the first point. And
Are they all translated into the BCS or into any other language that the accused understand?
It was provided in English language, and the translation will be provided within the time limits given by the rules.
Thank you.
And the second point is just already for the defense and for the trial chamber. The prosecution intends to amend the indictment, and not only in relation to the wrong birth date, but also in relation to substantial matters.
Well, for your information, the presiding judge of this trial chamber has assigned me the pre-trial judge for this case. you may file your motion for the amendment of indictment to me. Thank you. Is there any matter that defense wishes to raise at this stage? Mr. Kastrotovic.
Ja bih hteo u ime
Yes, Your Honor. On behalf of my client, Mr. Milan Martic, and in my own name, I should like to raise several important matters, several fundamental facts which determine our attitude to this tribunal. I have trusted the fairness of this tribunal ever since the day when my country was readmitted to the United Nations, and ever since I have not distinguished between the courts in my country and this court. My client, Mr. Milan Martic, began to trust this tribunal somewhat later when the democratic authority was instituted in our country and when cooperation with the tribunal started. Since then, Mr. Milan Martic has thought it his civic duty to...
Excuse me to interrupt you, Mr. Kastrotovic. You have to understand that whatever you said has to be translated into English and French, the two official languages of this tribunal. So please speak slowly and make a stop at every sentence so that the interpreter and the port recorder could catch up with you. I'm sorry for the interruption. You may proceed.
Ja se vama izvinjavam, uvaženi.
My apologies, Your Honor, and I will repeat only my last sentence. From that time on, the accused Martic has considered his civil duty to surrender himself to this honorable court, believing in its good faith and fairness, and trusting that in an unbiased procedure, through me, he will prove what he intends to prove. Needless to say, you have already decided that Mr. Martic be kept in detention. I would not insist on his release from detention because at this point in time I do not think that it would be justified. I also wish to inform you that Mr. Martic and I will do our best to very quickly, in a written submission, define or lay down the principal points of our defense to establish facts which are in dispute and which are not in dispute, so as not a bigger problem from what already is a problem, and thus encumber the court more. I hope that we shall be able to resolve a number of questions with the prosecutor before the main hearing, and that when the trial starts, you will have to deal only with matters which we have not been able to settle between us. As I have said, we do not want this case to be procrastinated because it would be at the expense of the court, of my client, and the justice. You will find in us collaborators who will abide by the procedure as envisaged by the rules. Thank you very much.
Very much. Madam Prosecutor, although you have informed this trial chamber that you have already disclosed the supporting material, but for the record, I have to remind you that pursuant to Rule 66 of the Rules of Procedure and Evidence, it has 30 days to disclose the supporting materials with the indictment. And defense is advised that it will have 30 days period for filing any preliminary motions once it has received all the supporting material in accordance with Rule 66 of the rules. You may challenge the jurisdiction, as well as file any other motions, like the motion for the provisional release of your client. For the expeditious preparation of the case, a status conference will be scheduled within 120 days from today, pursuant to the Rule 65 bis A. I believe that's all for this initial appearance. I'll now adjourn the proceedings.
All rise, veuillez vous lever.